Today, we come to the last in our four-part series on liberty, to the word liberty as it's used in the 5th and 14th Amendments, specifically the due process clauses. Those clauses in both amendments say that no person shall be denied liberty without due process of law. So, what is this liberty that the Constitution speaks of? It has a very defined meaning, historically developed, that the United States Supreme Court has run roughshod over to the detriment of real liberty and our Constitution and social ordering, and in the face of God, I would add. So let me trace this real quickly. We turn again to understanding the jurisprudence behind our nation's law, the common law, which provided the nomenclature and the phrases that were incorporated into the United States Constitution and the 14th Amendment, to William Blackstone's Commentaries on the Laws of Nature. And he says that men, people, human beings, have certain absolute rights and certain relative rights. We're going to focus today on absolute. What he means by absolute, and I'm looking here in his book, is that he said absolute was denominated, said to be natural liberty, the natural liberty of mankind. And here's how he defines it. This natural liberty consists properly in the power of acting as one sees fit without any restraint or control, unless by the law of nature, being a right inherent in us by birth and one of the gifts of God to man at his creation, when he endued him with the faculty of free will. Now he goes on to say, but every man, when he enters into society, gives up a part of his natural liberty as the price of so valuable a purchase as, of course, being able to live in society. And he says that no man who considers it for a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, because the consequence would be there would be no security of individuals in the enjoyment of their life. So that also, I would say, accords with our understanding of the Trinity, that there are individuals and there are communities, that Adam and Eve were individuals, but together they were to form a community, even as now in Jesus Christ a new community of humanity is being formed. So a magistrate who understands that they will present some kind of image of God to the people by their judgments would understand that they need to balance this natural liberty of the individual with the rights of the community, consonant with their understanding of the triune nature of God, with its distinction of persons and unity of existence. He then says that civil liberty is no other than the natural liberty, so far restrained by human laws and no further, as is necessary and expedient for the general advantage of the public. So again, we see this balance between the individual and the community, between the state and the individual, all to mirror our understanding of the triune nature of God and to our application of it in the arts of man, which would be in the development of laws that would order society. Okay? Now, as you'll recall from previous episodes, that civil liberty was also defined as simply the power of doing whatever the law permits. So therefore, it's very important that we understand what liberty is in the 14th Amendment, because that's what the Constitution permits, but also says it can be lost if you violate a law and you're provided due process to prove the violation of the law. In that case, for example, with murder, you could lose your life, or with other things, you could suffer jail time or fines. Okay? And in fact, I think Blackstone would have said that to abolish due process of law, given that it goes all the way back to the Magna Carta, would be unlawful per se, meaning you wouldn't have to pass a statute to say the abolition of due process of law is unlawful. It is per se unlawful, just like murder is per se unlawful, whether we ever pass a murder statute or not. So then, what do we mean by this natural liberty that informs civil liberty, that should inform the laws? And obviously, it can't mean everybody gets to do whatever they want. But within this notion of liberty and civil liberty is a further aspect of liberty called personal liberty. And here's what William Blackstone says about personal liberty. He says, this personal liberty consists in the power of locomotion, of changing situation or removing one's person to whatsoever place one own's inclination may direct, without imprisonment or restraint, unless by due course of law. So again, we see that if we don't understand what natural liberty is, and that it's not derived from society, it's endowed on man by God, and that part of that natural liberty consists in locomotion, moving around, changing jobs, going to this place or that, living here, living there, going to work, not going to work, whatever it might be. If we don't understand that, we'll develop civil laws that go beyond what is necessary in restraining that personal liberty. Of course, that's what we saw, I think, with COVID, right? That the needs of the community abrogated and overcame any rights of the individual. And that is a Trinitarian problem, okay? Now, what's happened with the United States Supreme Court is they took the word liberty. Well, let me back up. What's happened to the United States Supreme Court is, one, as I've said, in 1938, they made it clear there is no transcendent authority to law. The only authority is the state. Then, having done that, they divorced themselves from history because, after all, without God, history's not revealing anything. It's not really teaching us anything. It's just, as Mark Twain said, one damn thing after the next. And hopefully we learn something from it, but maybe we don't, and maybe there's nothing to learn from it. Okay, so that's where we are. So with that as a background, in 1973 and 1992, the Supreme Court affirmed that liberty is actually the right of a woman to hire a doctor to kill her unborn child. There we see the Supreme Court directly going into the face of the creational command and ordinance that we are to be fruitful and multiply. Not surprising when you deny God. Then in 2015, they said that civil law, the right of liberty includes the right to force a county clerk or other magistrate to issue a license under a statute for a marital relationship that will be called a marriage. Well, so much for God's creational understanding of what the marital relationship is, and it's not surprising that we see unfruitfulness and same-sex marriage being tied together by a court that's rejected God and rejected history and doesn't understand the meaning of the word liberty. So when we don't understand this history, and when our policy advocates and our legal advocates don't understand this history, and they continue to use as precedent for their positions recent cases that have perverted the understanding of law and perverted the understanding of liberty, don't be surprised that we lose our civil liberty, because those making the civil laws will not understand how far they can or cannot go, or should not go. And if you think that can't happen, let me just hearken back again to the Obergefell decision in 2015 that says all state statutes now, essentially, you should interpret them as creating marital relationships defined without regard to sex. So when ministers, for example, don't understand natural liberty and don't understand liberty as under the 14th Amendment, and don't understand civil liberty, well, they will, as agents of the states, go about signing government licenses that affirm that the marital relationship they've solemnized has nothing to do with sex in the eyes of the state. And so, in a sense, they have yielded their natural liberty, they have yielded what should be their civil liberty to the yoke of the state. I hope this four-part series has been helpful. Blessings. Bye.